à la réunion 125 du Comité permanent du patrimoine canadien.
We are now calling to order meeting 125 of the House of Commons, Standing Committee of Canadian Heritage. I would like to acknowledge that this meeting is taking place on the unceded traditional territory of the Algonquin and Anishinaabe people.
The motion adopted by the committee on February 14th, 2022, the committee is resuming its study on online harms. Before we begin, I want to ask you, all members and other in-person participants, to consult the cards on the table in front of you to take note of the preventative measures in place to protect the health and safety of the participants, especially the interpreters. Only use the black approved earpiece. Keep your earpiece away from all microphones, and there's a little decal in front of you that when you're not using your earpiece, you can put it down, face down on that decal. And thank you if you would do that, because we do have problems with interpretation sometimes and with feedback. Now, today's meeting is taking place in a hybrid format. And so in accordance with the committee's routine motion concerning connection and witnesses, I want to let you know that all the witnesses have completed their connection tests in advance of the meeting. Is that true, Clark? Yeah? Okay. Now, I want to make a few comments for the benefits of members and witnesses. Please wait until I recognize you by your name before speaking. Put your hand up. If you're in a chat, you have a little hand decal that you can put up. And if you're in the room, put your actual hand up, and I would recognize you. And a reminder that all comments should be addressed through the chair. And please do not take pictures of the meeting, because it's going to be produced online later on for you anyway. So, pursuant to the motion adopted by the committee on Tuesday, April the 9th, we have Claude Barreau, psychotherapist from Homewood Health, in the room with us today. Claude, can you put your hand up or stand up? Ready to go? So if you feel distressed or uncomfortable with some of the witnesses that you're hearing, and you feel you want to talk to him, he's here to help you out. And I want to welcome our witnesses. So we have our witnesses actually set up in a particular order, but I just wanted to flag the two witnesses who must leave at 4:30 p.m. And so they are Heidi Tworek, Associate Professor, University of British Columbia, and she's here by video conferencing. And they are Monique Saint-Germain, who is the General Counsel for the Canadian Centre for Child Protection, and she is here by video conference. They will be leaving at 4:30. But then from 3:30 to 5:20 p.m., or if because of the votes, we are starting later, we will have Shona Moreau from the Faculty of Law, McGill University, Chloe Rourke from the Faculty of Law, McGill University, Signa Dome-Shanks, Associate Professor, University of Ottawa, Faculty of Law, and Kita Semokuto, lawyer. Sorry, Kita, did I pronounce your name okay, or did I muck it up?
That was fine, thank you.
Oh, good, okay, thank you. So now, before we begin, I just wanted the witnesses to know that you each have 5 minutes, but not each. If you represent a group, then that group has 5 minutes. So I noticed we have two people from McGill, so you can decide who's going to be your speaker. I will give you a 30-second shout out, and I mean shout out. I'll go 30 seconds, and then you can wrap up what you're saying, because you will have an ability later on, or the opportunity to be able to finish up some of the things you want to say when you get the question and answer period. So thank you very much, and now begin with Heidi Tworek from British Columbia for 5 minutes, please, Heidi.
Thank you, Madam Chair, for the opportunity to appear virtually before you to discuss this important topic. I'm a professor and Canada Research Chair at the University of British Columbia in Vancouver. I direct the Centre for the Study of Democratic Institutions, where we research platforms and media. And 2 years ago, I served as a member of the expert advisory group to the Heritage Ministry about online safety. So today I will focus on three aspects of harms related to illegal sexually explicit material online before discussing briefly how Bill C-63 may address some of these harms. First, the issue of illegal sexually explicit material online overlaps significantly with the broader question of online harm and harassment, which disproportionately affects women. A survey in 2021 found that female journalists in Canada were nearly twice as likely to receive sexualized messages or images, and they were 6 times as likely to receive online threats of rape or sexual assault. Queer, racialized, Jewish, Muslim, and Indigenous female journalists received the most harassment. Alongside provoking mental health issues or fears for physical safety, many are either looking to leave their roles or are unwilling to accept more public-facing positions. And others have been discouraged from pursuing journalism at all. My work over the last 5 years on other professional groups, including political candidates or health communicators, suggests very similar dynamics. This online harassment is a form of chilling effect for society as a whole, when professionals do not represent the diversity of Canadian society. Second, generative AI is accelerating the problem of illegal sexually explicit material. Let's take the example of deep fakes, which means artificially generated images or videos that swap faces onto somebody else's naked body to depict acts that neither person committed. Recent high-profile targets include Taylor Swift and US Congresswoman Alexandria Ocasio-Cortez. These are not isolated examples. As journalist Sam Cole has put it, sexually explicit deepfakes meant to harass, blackmail, threaten, or simply disregard women's consent have always been the primary use of the technology. Although deepfakes have existed for a few years, generative AI has significantly lowered the barrier to entry. The number of deepfake videos increased by 550% from 2019 to 2023. Such videos are easy to create because about 1/3 of deepfake tools enable users to create pornography, which comprises over 95% of all deepfake videos. One last statistic, 99% of those featured in deepfake pornography are female. Third point, while it is mostly prima facie easy to define illegal sexually explicit material, we should be wary of platforms, online platforms, offering solely automated solutions. For example, what if a lactation consultant is providing online guidance about breastfeeding? Wholly automated content moderation systems might delete such material, particularly if trained simply to search for certain body parts like nipples. Given that provincial human rights legislation protects breastfeeding in much of Canada, deletion of this type of content would actually raise questions about freedom of expression. If parents have the right to breastfeed in public in real life, why not to discuss it online? What this example suggests is that human content moderators remain necessary. It is also necessary that they are trained to understand Canadian law and cultural context, and also to receive support for the very difficult kind of work that they do. Finally, let me explain how Bill C-63 might address some of these issues. There are very legitimate questions about C-63's proposed amendments to the Criminal Code and Canadian Human Rights Act. But as regards today's topic, I'll focus briefly on the online harms portion of the bill. Bill C-63 draws inspiration from extant legislation in the European Union, United Kingdom, and Australia. This makes Canada a fourth or fifth mover, if not increasingly an outlier in not regulating online safety. But Bill 63 suggests 3 types of duties for platforms. The first 2 are a duty to protect children and a duty to act responsibly in mitigating the risks of 7 types of harmful content. The third, most stringent and relevant for today, is a duty to make 2 types of content inaccessible: child sexual exploitation material and non-consensual sharing of intimate content, including deepfakes. And this should theoretically protect the owners of both the face and the body used in a deepfake. A newly created Digital Safety Commission would have the power to require removal of this content in 24 hours, as
30
well as
seconds.
impose fines and other measures for non-compliance. C-63 also foresees the creation of a digital safety ombudsperson to provide a forum for stakeholders and to hear user complaints if platforms are not upholding their legal duties. This ombudsperson might also enable users to complain about takedowns of legitimate content. Now, Bill C-63 will certainly not resolve all issues around illegal sexually explicit material. For example, how to deal with copies of material stored on servers outside.
Thank you, Ms. Tuareg. I would advise you to wrap up. You can expand on this later on in the question and answer section. Thank you.
Thank you.
Do you want to finish your sentence? Go ahead.
Yes, I would. So this is actually my final sentence. Anyway, just to say that C-63 is a step in the right direction to address a problem that tragically is swiftly worsening, and I'm looking forward to your questions.
Canadian Center for Child Protection, Monique Saint-Germain. For 5 minutes, please, Ms. Saint-Germain.
Thank you for the opportunity today. My name is Monique St. Germain, and I am General Counsel for the Canadian Centre for Child Protection, which is a national charity with the goal of reducing the incidence of missing and sexually exploited children. We operate cybertip.ca, Canada's national tip line for reporting the online sexual exploitation of children. CyberTip receives and analyzes tips from the public and refers relevant information over to police and child welfare as needed. CyberTip averages over 2,500 reports a month, and since inception, over 400,000 reports have been processed. When CyberTip launched in 2002, the internet was pretty basic, and the rise of social media was still to come. Over the years, technology has rapidly evolved without guardrails and without meaningful government intervention. The faulty construction of the internet has enabled online predators to not only meet and abuse children online, but to do so under the cover of anonymity. It has also enabled the proliferation of child sexual abuse material at a rate not seen before. Victims are caught in an endless cycle of abuse. And things are getting worse. We have communities of offenders operating openly on the Tor network, also known as the dark web. They share tips and tricks about how to abuse children and how to avoid getting caught. They share deeply personal information about victims. CSAM is openly shared not only in the dark recesses of the internet, but on websites, file sharing platforms, and forums and chats accessible to anyone with an internet connection. Countries have prioritized the arrest and conviction of individual offenders, and while that absolutely has to happen, we've not tackled a crucial player, the companies themselves, whose products facilitate and amplify the harm. For example, Canada has only one known conviction and sentencing of a company making CSAM available on the internet. One. And that prosecution took 8 years and thousands of dollars to prosecute. Criminal law cannot be the only tool. The problem is just too big. Recognizing how rapidly CSAM was proliferating on the internet, in 2017 we launched Project Arachnid. This innovative tool detects where CSAM is being made available publicly on the internet and then sends a notice to request its removal. Operating at scale, it has issued roughly 10,000 requests for removal each day, some days over 20,000. To date, over 40 million notices have been issued to over 1,000 service providers. Through operating Project Arachnid, we've learned a lot about CSAM distribution, and through cybertip.ca, we know how children are being targeted, victimized, and sextorted on the platforms they use every day. The scale of harm is enormous. Over the years, the CSAM circulating online has become increasingly disturbing, including elements of sadism, bondage, torture, and bestiality. Victims are getting younger, and the abuse is more graphic. CSAM of adolescence is ending up on pornography sites where it is difficult to remove unless the child comes forward and proves their age. The barriers to removal are endless, yet the upload of this material can happen in a flash, and children are paying the price. It's no surprise that sexually explicit content harms children. For years, our laws in the offline world protected them, but we abandoned that with the internet. What we know is that everyone is harmed when exposed to CSAM. It can normalize harmful sexual acts, lead to distorted beliefs about the sexual availability of children, and increase aggressive behavior. CSAM fuels fantasies and can result in harm to other children. In our review of Canadian case law regarding the production of CSAM in this country, 61% of offenders who produced CSAM also collected it. CSAM is also used to groom children. Nearly half of the victims who responded to our survivor survey of victims of CSAM identified this tactic. Children are unknowingly being recorded by predators during an online interaction, and many are being sextorted thereafter. More sexual violence is occurring among children, and more children are mimicking adult predatory behavior, bringing them into the criminal justice system. CSAM is a record of a crime against a child, and its continued availability is ruining lives. Survivors tell us time and time again that the endless training in their CSAM is a barrier to moving forward. They are living in constant fear of recognition and harassment. This is not right. The burden of managing internet harms has fallen largely to
30
parents.
seconds.
This is unrealistic and it's unfair. We are thrilled to see legislative proposals like Bill C-63 to finally hold industry to account. Prioritizing the removal of CSAM and intimate imagery is critical to protecting citizens. We welcome measures to mandate safety by design and tools like age verification or assurance technology to keep pornography away from children. We would also like to see increased use of tools like Project Arachnid to enhance removal, prevent the re-upload of CSAM, and as others have said, public education is critical. We need all the tools in the toolbox. Thank you.
Very much. I now go to Ms. Morrow and Ms. Rourke, who is going to be the spokesperson. You will share it?
If possible, yes.
Then, but you still only have 5 minutes.
Yes.
You know that. Okay, thanks.
Absolutely.
Go ahead. Which one of you would begin first?
I will begin, if possible. Thank you so much.
Thank you. Ms. Rourke, yeah?
Parfait. Shona.
No,
Moreau.
Ms. Morrow. Yes?
Thank you.
Thank you.
Madame la Présidente, Mesdames et Messieurs les membres du
Madam Chair, members of the Standing Committee on Canadian Patrimoine, thank you for the invitation to appear before you today. While this study covers a wide range of topics, we are here to highlight one very specific dimension: the need to combat the growing threat of deepfake pornography, deepfake, and its effects on women and girls in Canada.
presentation will touch on 3 key aspects of deepfakes. 1, what is it? 2, who is affected? And lastly, what can be done about it? So deepfake technology, as you know, is generative AI that creates fake audiovisual content by manipulating a person's appearance and likeness. But as the technology advances, AI-generated content has become increasingly sophisticated and harder to distinguish from real-life footage. Lifelike deepfakes can now be generated using just a single photo of a person. And as a result, it's not just celebrities and public figures who are vulnerable. Everyone is vulnerable to this technology. And though there are other applications to deepfakes, by far the most common use is non-consensual porn. The vast majority of deepfakes are pornographic, and these overwhelmingly feature female subjects. It's important for the committee to know that this gendered and sexualized use of the technology is not new. The term deepfake actually originated in 2017, stemming from the practice of using online tools to switch female celebrities' faces onto pornographic videos. So in other words, non-consensual porn has kind of been central to the technology since its very beginning. And while the unauthorized use and creation of fake intimate images is not a new phenomenon, Photoshop, for example, has been around for decades, the advent of generative AI technology has taken this issue to a whole new level.
30 seconds.
Today, highly realistic and convincing fake pornographic content can be produced quickly and with minimal efforts and skills. Even when fake, these types of images inflict real emotional, societal, and reputational harm on victims, and now even children are affected. In the past year, reports have exploded of schoolgirls who have found themselves the subject of pornographic deepfakes made and shared by their own classmates. All this to show that deepfake porn is not a trivial matter. It's real, it has a significant threat on people and on human dignity, and as such, it demands our attention and action.
Thank you, Ms. Rourke. You have 2 minutes and 16 seconds. Thank you.
To effectively address this issue, it's crucial to understand how existing laws can be extended to cover deepfakes, but also why current regulatory frameworks are insufficient. Firstly, Canadian legislation prescribing the non-consensual distribution of pornography, such as Section 162.1 of the Criminal Code, should be reviewed and extended to include altered images such as deepfakes. This sends a clear message that it is wrong and must be denounced. However, it is important to recognize that this is not enough. Unlike a real recording, deepfakes are not tied to a specific time, location, or sexual partner. They can easily be produced and distributed anonymously. And so in practice, it will often be difficult to identify perpetrators and hold them legally accountable, which will limit the deterrent effects of such provisions. Additionally, even when an individual perpetrator is identified, criminal or civil penalties cannot restore a victim's privacy, dignity, or sense of safety, particularly when the content continues to circulate in the public domain. To address these ongoing harms, we must consider the role and responsibility of digital platforms. Tech platforms such as Google and pornography websites have already created procedures that allow individuals to request non-consensual porn of themselves be removed and delisted from their websites. This is not a perfect solution. Once the content is distributed publicly, it can never be fully removed from the internet, but it is possible to make it less visible and therefore less harmful. Implementing such systems would mitigate the reputational harm caused by non-consensual porn, whether it be real or synthetic, and provide a more immediate and practical recourse for victims. Public regulatory bodies should work with major online platforms to require such procedures and ensure they are effective, accessible, and meaningfully enforced.
30 seconds.
Lastly, this technology must be understood within the context of gender-based violence and societal attitudes towards women's sexuality. The non-consensual sharing of porn already is weaponized against women and is further exacerbated by deepfakes because anyone is able to create and distribute such content. Women will have limited options to protect themselves, and is already being used to target, harass, and silence female journalists and politicians. If unchecked, deepfakes threaten to rewrite the terms of participation in the public sphere for women. This technology is rapidly evolving and harms have already materialized. While no one law can eliminate it, we can take action, and legislators have a role to lead these efforts. Thank you.
Thank you, Ms. Rourke. I now go to Mr. Shanks. Ms. Shanks, sorry, University of Ottawa, Faculty of Law.
Thank you.
Ms. Shanks for 5 minutes. Thank you.
I'm a law professor at the University of Ottawa and a law professor on leave at Osgoode Hall Law School. I belong to the Law Society of Ontario. I specialize in the history of laws, the impact of laws on marginalized peoples, law and economics, and tort law. I've taught at the university level for 26 years. Teaching has also included updating the judiciary about trends in law and professional development sessions for the legal profession. Today, I'm going to focus on the influence of tort law upon legislation. Why? It is directly responsible for responding to harm. Tort law is also a subject that has allowed courts to respond to matters not addressed in legislation yet. It has its benefits and shortcomings for making society better. It is considered part of private law and includes topics like personal injury, intentional infliction of mental distress, intimidation, and breach of fiduciary duty, such as to children or the increasing topic involving Indigenous peoples. For me, 2 observations surface about legislation regarding harm. First, I think about how private law interacts with legislation. Historically, many topics in private law have come across a judge's bench because parties, and ultimately the judge, have concluded that society would support the recognition of a certain harm. The harm, however, may not be articulated yet in legislation and may seem novel. However, those topics are constructed on jurisprudence. So while the name of a tort might be new, the details of the tort are familiar and already supported. Tort law has helped create tools which have been and are integrated into legislation. Like other topics in law, there is often what is called a dialogue. Events in society impact arguments in court. Those arguments in court are learned about by those who create and implement legislation, like all of you. In this dialogue, sometimes the legislation introduces the idea first, and views about the legislation will then be brought up by parties in the courtroom. On this idea that private law and legislation have an ongoing relationship, it is vital to also realize almost all tort litigation does not result in a trial decision. As a result, any litigating, negotiating, and resolving happens at earlier stages of litigation. And in fact, those earlier stages are organized by the courts and involve many parties, including judges, to evaluate the nature and scope of the claimed harm. So when a tortious subject is not guided by legislation, figuring these subjects out takes time and space in the court system. All of us know stories where people have felt less heard due to the slowness of the court process. That slowness is arguably magnified when legislation does not exist to quickly determine one part or all parts of a problem. Private law has helped get some harms more recognized, but when the private law's focus on harm does not have legislative guidance, addressing examples of harm and preventing that harm can take time and arguably increase the number of times that said harm occurs. My second observation is about when legislation is proposed. I see any legislation about online harm, particularly when it impacts groups who we consider more vulnerable, capable of paralleling the benefits of private law, plus avoiding some of private law's limitations. Demanding a party act responsibly, for example, is mirror-like to negligence law, and the concept is also prevalent in many intentional torts, such as intentional infliction of mental distress. It might be a word we are now integrating, but the word's presence is already evident. Moreover, we can learn how other countries have found acting responsibly is possible to have into a right-based system, like Canada's. I believe we have the underpinnings of acting responsibly already in Canadian law. Legislation has also an effective dissuasion that private law might not have. Legislation hopefully stops most intentional harm before it happens. Introducing such subjects via legislation influenced by tort law, especially when subjects are urgent due to their own form and growth, creates a type of social and judicial efficiency that trends in private law often lack. Thank you for including the duty of acting responsibly, so that courts and society will have more guidance about how to evaluate them. It is my view this duty makes legislation stronger and the need for lawsuits less likely. Thank you for this opportunity, and I look forward to our discussion.
Thank you, Ms. Shanks. I now go to Mr. Semak Uto, please, for 5 minutes.
Madam Chair, committee members, thank you for the opportunity to speak before you this afternoon. By way of brief background, my name is Keita Semak Uto. I'm from Vancouver. I was just called to the bar last month, and I've been practicing primarily in family law with also a mix of privacy and workplace law as well. I attended law school at Dalhousie in Halifax, and while there I took a privacy law course. I chose to write my term paper on the concept of deepfake videos, which we've been discussing today. I was interested in the way that a person could create a deepfake video, specifically a sexual or pornographic one, how that could violate a person's privacy rights. And in writing that paper, I discovered the clear gendered dynamic to the creation and dissemination of these kind of deepfake videos. As a case in point, around January of this year, somebody online made and publicly distributed sexually explicit AI deepfake images of Taylor Swift. They were quickly shared on Twitter, repeatedly viewed. I think one photo seen as many as 50 million times. And in Associated Press article, a professor at George Washington University in the United States, she referenced women as canaries in the coal mine when it comes to the abuse of artificial intelligence. She quoted, "It's not just going to be the 14-year-old girl or Taylor Swift. It's going to be politicians. It's going to be world leaders. It's going to be elections." So even back before this in April 2022, it was striking to see the capacity for essentially anybody to take photos of somebody's social media, turn them into deep fakes, and distribute them widely without really any regulation. And again, the targets of these deep fakes, while they can be celebrities, they can be world leaders. Oftentimes it's people without the kind of finances or protections of a well-known celebrity. And so worst of all, I think, in writing this paper, I discovered there is really no adequate system of law yet that protects victims from this kind of privacy invasion. I think that's something that really is only now being addressed with somewhat with the Online Harms Bill. I did look at the criminal code. There's section 162, which prohibits the publication, distribution, sale of an intimate image. But the definition of intimate image in that section is a video or photo in which a person is nude, the person had a reasonable expectation of privacy when it was made or when the offense is committed. And again, I think the reasonable expectation of privacy element will come up a lot in legal conversations about deepfakes. When you take somebody's social media photo that's taken and posted publicly, it's questionable whether they had a reasonable expectation of privacy when it was taken. So in the paper, I looked at a variety of torts, which I thought, if the criminal law can't protect victims, perhaps there is a private course of action in which victims can sue and perhaps get damages or whatnot. I looked at public disclosure of private facts, intrusion upon seclusion, other torts as well, and I just didn't find any of them really satisfied the circumstances of a deepfake, pornographic deepfake scenario. Again, with the focus of reasonable expectation of privacy not really fitting the bill. As I understand today, there have been recent proposals for legislation and legislation that's come into force. In British Columbia, there's the Intimate Images Protection Act. That was from March 2023. And the definition of intimate image in that act, it means a visual recording or visual simultaneous representation of an individual, whether or not they're identifiable, and whether or not the image has been altered in any way in which they're engaging in a sexual act. And I think the broadening of the definition of intimate image, not just an image of someone who is engaged in a sexual act when the photo is taken, but altered to make that representation, that seems to be covered in the Intimate Images Protection Act. The drawback of that act is that while it does provide a private right of action, the damages are limited to $5,000, which seems negligible in the grand scheme of things. I suppose we'll talk more about Bill C-63 in this discussion, and I do think that it goes in the right direction in some regard. It does put a duty on operators to police and regulate what kind of materials online, and another benefit is that it expands the definitions again of the kinds of material that should be taken down. So that act requires the operator to, or once passed, it'll require the operator to take down material that sexually victimizes a child or re-victimizes a survivor. And that
Thank you,
definition.
Mr. Semakuto. Can you wind up, please?
Yes.
Thank you.
I'll conclude there. Great.
I'm now going to go to the question and answer session. Before I begin, though, I'd like the committee to know that we have until 5:45. And so I would like us to have 15 minutes. So I'd like to end at 5:30. So we will have in-camera work for 15 minutes. So we're going to just try and fit everybody and their questions into that space. So now we go to the first round of questions. They're 6-minute questions. And I begin with the Conservatives. Rachel Thomas, Ms. Thomas, for 6 minutes, please.
Thank you. Thank you, witnesses, for giving us your time here today and for sharing your expertise. My first question goes to Ms. Morrow and Rourke. My question for you, you talked about in your opening statement, you said that the criminal code should be expanded in order to include deep fakes, but then you went on to say that this isn't actually enough, that we must also consider the role that platforms play and that government has a responsibility to ensure that there are teeth in terms of holding those platforms accountable. In an article that you recently wrote, just in February, you said, updated telecom regulations can play a part, but Canada also needs urgent changes in its legal and regulatory frameworks to offer remedies for those already affected and protected against future abuses. So you seem to be outlining that both are needed. I'm just wondering if you can expand on that.
Yeah, so our position is similar to what was discussed, and that the criminal code provision would need to be amended if it were to apply to altered images and deepfakes in our interpretation, and that while that's important, it's not going to provide a remedy in many cases, in part because deepfakes are so easy to produce anonymously that the person that produced them in many cases won't be identifiable. And as we discussed, it won't necessarily provide the remedy that all victims are seeking, or a complete remedy, in the sense that the content itself can continue to cause reputational harm and continue to be circulated. So it's our position also that it would be important to work with and have platforms be held accountable for the content that's being distributed on their websites. They're the ones that have control over the algorithms that are listing the results, and the ones that can take that content down and at least make it less visible, if not remove it entirely. And I can defer to my colleague for the further comments.
Yes, so I echo everything that my colleague Chloe has said, but also I think what's just really we feel desperate when we see this is that if you search up just deep AI, nude AI, anything like that, they are so easily accessible. It just pops up on Google. You put a picture, you pay like $3, and you're able to generate massive amounts of deepfakes of an individual or many if you choose. And so that accessibility is really what we're fighting for the most, because as we know, litigation can take many, many years and oftentimes doesn't really make a victim whole. So it's just really about the ability to make sure these platforms don't as easily make this technology available for anyone, but also, as we've seen, children have an ability to use this, and they might not know the consequences or realize how detrimental they are on the victims.
Thank you. So Bill C-63 does something really interesting. So rather than updating the criminal code to include deepfakes, it actually doesn't do that at all. Deepfakes isn't mentioned in the bill and folks are not protected from them, not in any criminal way. So I believe that's an issue. And then secondly, with regards to platforms, they will be subject to perhaps an assessment and a ruling by an extrajudicial bureaucratic arm that will be created. But again, there's actually nothing criminal attached to platforms allowing for the perpetuation of things like deepfakes or other non-consensual images. Does that not concern you?
I can take this one first. I think as everyone has kind of all the witnesses today have talked about, I think it's a really good step in the right direction. We are really here in order to showcase that this is a big issue and needs to have further steps. So I think, as you said, if there's more work that we can do to protect, specifically, as we've talked about, children, women, schoolgirls from this technology, it should be taken. And I think that if there's that possibility of further legislation in the future, or as you talked about, having a body that takes this on and more studies about this, I think it would very much be beneficial, because this is not an issue that's going away. AI technology is rapidly expanding more than we can even predict its effects. And so I think that almost, you could argue, needs to be a constant committee and study on these new and innovative issues that are coming through this technology. And I think my colleague Chloe wants to talk a bit as well.
Sure. I am just running out of time, so if comments could be brief.
I was just going to add that I think the criminal code provisions that currently exist applying to actual real recordings of intimate images or so-called revenge porn, it's an incomplete remedy as it exists, not even including the issue of deepfakes and how much more complicated it is to apply there. So I think our bigger priority is what are the accessible remedies that can be implemented in the vast majority of cases, because there are many revenge porn cases that would never be litigated or criminally prosecuted, and the harm continues. And that's why I think involving the platforms is really important in that respect.
Sure. Thank you very much. Mr. Simicuto,
35 seconds, Rachel.
I did intend to leave you more time. I'm not sure if you wish to comment.
Do you mind repeating the last part of the question?
We're probably out of time. So
Okay.
I'll maybe just conclude by saying this. Look, I think at the end of the day, what's being made clear at the table is that, it's not enough just to signal good intentions, but rather what I'm hearing from folks is that we do need an updated criminal code in order to go after those that would create and propagate deepfakes. I think that's really important for all women across our country, because I think what the witnesses have certainly drawn attention to is that this is a gendered issue. It is women and girls who are subjected to it far greater than men. And it does ruin lives. And so I think the government has a responsibility to act on that.
You're going over. Thank you. And now I go to Michael Coteau for 6 minutes. Michael?
Thank you very much, Chair. And thank you to all of our witnesses here today. I appreciate the work that you're doing to protect young people and all Canadians from online harm. My first question will go to Ms. Torwick. We heard from a professor from Colorado a few days ago, Mr. Krishnamurthy, I believe it's pronounced, Krishnamurthy. And he said something interesting. He said that sometimes, one of the big challenges is the elephant and mice in the room. The big platforms obviously are the ones that have a lot of control, but it's also the small entities online that come and go quickly. That regulators, it's hard to keep up with these fly-by-night websites. What's your thoughts on how we go about tackling that challenge that was presented at the last Heritage meeting?
Yeah, thank you very much. So I serve with Mr. Krishnamurti on the expert advisory group, and this is something that we grappled with quite a lot because, of course, the major platforms like Facebook and so on have many, many employees and can easily staff up, but we often see these harms, particularly now with generative AI lowering the barrier to entry. There could be a couple of individuals who create complete havoc or very small firms. And so the question, I think, then there's two aspects to this. One is, I think, the very important question of international cooperation on this. So we've talked as if all of the individuals creating harm would be located in Canada, but the truth is that many of them may be located outside of Canada. So I think we need to think about what international cooperation looks like. We have this for counterterrorism in the online space, and we need to think about this for deepfakes. And then in the case of smaller companies, we can divide between those who I think are being abused, and then there's the question of how the new proposed online bill, C63, could have a digital safety commissioner who actually helps those kind of smaller firms to ensure that these deepfakes are removed. And then finally, we have the question of the sort of the more nefarious smaller firm actors and whether we need to have Bill C63 be expanded to be able to be nimble and shut down those kinds of nefarious actors more quickly, or, for example, tools that are only really being put up in order to create deep fakes of the terrible kinds that have been described by other witnesses. So I just emphasize that the international cooperation finally is key, because only taking things down in Canada is potentially going to lead to re-victimization, as something might be stored on a server in another country and then continually re-uploaded.
You talked about a massive increase of deep fakes. I think 550%, you said something around there. Obviously, the technology is shifting quickly. You know, over the course of my lifetime, we've seen technology just rapidly shift. I think, you know, I've gone from buying the same album, you know, as a record, cassette, disc, and MP3, and that's just like in the music sector. But, you know, technology is constantly shifting. I was reading recently about, you know, AI agents that can be created that, you know, have a mind of their own and that they can be programmed to do things themselves, right? Was there any discussion around how, you know, a specific AI agent can be programmed to do stuff on their own that relates to online harm?
So we didn't specifically discuss generative AI that much within our group, but I think that within Bill C63, there's certainly at least an attention to the question of deepfakes. And I think that the concept of a duty to act responsibly is hopefully capacious enough to be able to deal with these kinds of updates. So if we're thinking about generative AI companies, they too will have a duty to act responsibly. And then I think the questions become, what exactly should that duty to act responsibly look like in the case of generative AI? And a lot of things we've been talking about today would obviously be a very central part of that.
Thank you very much. Another question to Monique Saint. Is it Germain? Yeah, hi. Thank you again for being here. Thank you for the work you're doing around the protection of children. What happens when AI has become, you know, the technology is so good that it can create, you know, without using a deep fake, it creates images and videos of illegal sexual exploits and acts that may look so real, but they're actually fake. So there is no technical, like no living victim, but it obviously has a harsh impact on a sector and on society as a whole. Is that becoming more of a problem where you have a name, like a person who doesn't exist, but the exploitation of that image is being used more and more and more? Can you talk about that?
Yes, absolutely. So we've been talking a lot about sort of adults and the NCDII.
You have 28 seconds.
This is also happening in the space of child sexual abuse material. So there's a lot of harm that is done in terms of the systems that detect this type of material rely on hash values of real material, and the fake material doesn't have those hash values in the databases that are being relied on. So removal becomes an incredible challenge. And then there are all sorts of new CSAM that is out there, which there's already a lot of CSAM out there, so we're now talking about making it
What do you
even
call
more.
it? C-SPAN?
Child sexual abuse material.
Okay.
The criminal code still calls it child pornography, unfortunately.
Interesting. Okay, that's a big definition change necessary. Thank you so much for your time, and I appreciate you being here.
Thank you.
Thank you, Michael. I now go to the Bloc québécois. Martin Champoux. Martin, you have 6 minutes.
Madame la Présidente, avant de commencer, simplement peut-être signaler aux
Madam
techniciens.
Chair, I'd like to simply point out before I begin that microphone number 9 seems to still be open.
Merci, Madame la Présidente.
Thank you, Madam Chair.
Rachel, thank you. Go ahead, Martin.
Merci, Madame la Présidente. Merci.
Thank you, Madam Chair. Thank you to our witness as well for being here with us. I think this is a very important topic for all of us, even though sometimes in how we address this issue, we may have different opinions. I think each of the parties represented here and each member nevertheless has a single objective, that is to make surfing on the internet safer and to ensure that our children, our women, our girls, etc., can feel safe and can be sheltered from this kind of reprehensible behavior. Ms. Moreau, Ms. Rourke, you spoke about, among other things in your article and in your opening remarks, about the fact that deepfakes do not only impact stars, celebrities, and that is the perception we usually have. And as was mentioned by one of our witnesses, when we see images of Taylor Swift, for instance, in pornographic positions. But anybody, whether it be a politician during a campaign, or anybody can be impacted. Are there many of these? Have you observed many cases where simple citizens who are not well known have been the victims of deepfakes, sexual deepfakes? Yes, in our article, as we indicated briefly, there are ordinary citizens who have been victimized, and that's been the case since 2017. It is not new. And currently, we're also seeing a lot of advertising in the newspapers showing that this is really catching fire and becoming an issue in schools. In December, in Winnipeg, we heard that there was one school where almost 40 young girls were victimized by this technology, and that is a great number. So that's one story, and I'm sure that there are many more such stories everywhere, but it is becoming increasingly popular because the technology is becoming more accessible. It's easy to produce. There are apps that allow you to easily produce this. It's terrible. We've spoken a great deal about Bill C-63, which aims to regulate somewhat the hateful content and inappropriate content online. But beyond legislation, do you have a sense that the platforms could do more? Do you believe that these platforms have the technological tools right now to do this, and more? They have actually more than they're stating.
I think it's possible. I mean, certainly once the technology became open source, it's impossible to completely remove the technology and the capacity to create deepfakes from the internet. That's for sure. But it could be less accessible. I think decreasing the accessibility would decrease the frequency of these types of attacks. Just as an example, while we were doing research for this article, if you type in, deep nude into Google, the first results, you'll get 10 different websites you can go access, and it can be done in minutes. It's possible to make it less visible and less accessible than it is now. And I think it's pretty unnerving just how easy and how accessible it is. And I think that's why we're seeing, teenagers use it. And that's why a criminal remedy would just be inadequate, or even civil remedies are just inadequate considering how accessible it is.
Mais les géants, là, les Google, les compagnies, par
But what
exemple,
about the giants, Google and company, as you've indicated? And all you have to do is enter a few keywords into Google and you find a great deal of information. But some are claiming that it's impossible to impose controlling this content at the source, that you can't impose this on them. I cannot believe that they're unable to have some kind of red flag. Is there not some kind of mechanism they could use to say, wait a minute, this is a red flag and this is inappropriate? So if we were to make them more accountable, if we were to compel them to better control the content that's available, and when it's inappropriate, would that not help from the outset? Because legislation is wonderful, it's good to legislate and to punish and to sentence, but if that technology exists, I think at the very least these companies who supply content to whomever be held more accountable. Of course, I cannot speak on behalf of these platforms. I'm not here to represent them, but I think that everybody would benefit in ensuring that this kind of technology is not easily accessible to safeguard the reputation of these platforms. I think they would like to work on that. And we've seen that when they see that there is an issue, when there's a problem, there is remedy available to them to remove content. Now, we've spoken a great deal about what we can do. We've spoken about your expectations vis-a-vis us as representatives. As a parent, what do I tell my daughters? That you'll be working over the next year to ensure that this no longer remains a problem and that they will not be victimized by these technologies. Are there measures we can take to ward off this threat? Is there something that they can do? Because obviously they share their pictures with their friends and they send all kinds of data everywhere. Well, I think that's something that frightens us from these technologies, that it's no longer the idea that we mustn't take pictures of you and to give them to your friends or your boyfriend or others. It's simply there. It's out there. And we're absolutely vulnerable. We have no power to remove this. We need leadership on that, and we need to have people who come up with the solutions, and that it won't only be legislation, but to develop solutions quickly so that we can remove that kind of material from the internet. Thank you very much.
I now go to the New Democrats, Nikki Ashton, for 6 minutes, Nikki.
Thank you very much. I just saw Ms. Rourke, you had your hand up. Did you want to complete? I have some questions, but if you wanted to add what you were going to say.
That's very kind. I was just going to add that I think you have to see that this technology exists within a societal context of gender-based violence and oppression. And I think education and combating that societal cultural context is part of the solution. It's not going to fix the technology, but educating in schools to understand the harms so that the teenage boys that have access to technology know why it's so harmful. I think that's part of the solution. Nothing's going to be, no one single thing will fix it, but.
Thank you. And speaking of education, I actually wanted to direct my first question to Ms. Saint-Germain, and in part because the extent to which it's clear we are failing Canadian kids. Looking at the statistics, that's very clear. We've heard of the 15,630 incidents of online sexual offenses against children, 45,816 incidents of online child pornography reported by police in Canada from 2014 to 2022. And we know that the rate of police-reported online child pornography has almost quadrupled since 2014, and you spoke of some of these trends. Specific to the non-consensual distribution of intimate images, we also see a heartbreaking image emerge. Most people accused of this offense are of a similar age to their victim, and we know were previously known to the victim. In these situations, it's clear it's kids victimizing kids without necessarily understanding all of the ramifications, both for the victim's future and that, of course, of their own, the perpetrator. I want to get back to the topic of education that you talked about. How important is education around consent, around sexual safety? When it comes to young people, what more can we be doing to teach them how to keep themselves and each other safe?
Yeah, so I mean, education is always a critical component of any policy or initiative that we have. So we've got lots of different tools in the toolbox. We have our criminal law. We have potentially Bill C-63 coming forward to provide some regulatory. And then on the education side, obviously ensuring that young people are educated about sexual consent, understand the ramifications of sharing intimate images, of creating this type of material, etc. But we can't lose sight of the fact that the reason that they can do these things is because of the platforms that facilitate this kind of harm. So while we can have education, and we should have education for parents and for kids, taught through schools and available in a lot of different mediums and the places that kids go, we also need to make sure that we don't lose sight of the fact that there are other actors in the ecosystem that are contributing to the harm that we're all seeing.
I believe you did refer to Project Arachnid in your presentation. I'd like to get back to that. Can you describe the process and work it took to develop this, which I know you've referred to, and what other tools are you missing that we should be encouraging government to help you with?
Yeah, well, so our organization, as I had mentioned, has been operating cybertip.ca for a long time. So we are very steeped in technology, and our technological team is very sophisticated in terms of ensuring that the work that we do is done in the most efficient way and that we're not overexposing our staff to things that they don't need to be exposed to. So we leverage technology in a lot of different ways through Project Arachnid. It took a lot of time to develop that system. It's been being tweaked over the last several years, and it's gotten better at doing what it's doing. So what we have now is we have a very, very robust source of data that can be relied upon, not just by companies, but also by governments and other actors, because there's a lot of known material out there that human beings have already laid eyes on, already classified, and that material can come off the internet, but we need to start using those tools in the ways that make sense, instead of overexposing victims to having their imagery repeatedly looked at by different moderators in different countries that have less robust safeguards than we have in the institutions like our own and in policing that do this work on a daily basis.
I want to get to also the big question around stigma that victims face in terms of coming forward. We know that the most recent data provided by Statistics Canada says that in 2022, over 2,500 police reports of non-consensual distribution of intimate images were made. And we know, of course, from when it comes to sexual assault, that there's a real issue of underreporting given victims' lack of trust in the justice system, the policing system, and fearing the stigma that they will face. And I'm wondering, how do we fix this question of stigma in terms of the work that you're involved in and what you're seeing with young people?
Well, I mean,
5 minutes to do that?
I'm sorry?
5 minutes to do that.
Okay, I'm now I've lost track of the question. I'm sorry.
No problem. Just on stigma, dealing with the stigma.
Okay, so yes, I mean, victims are facing a real stigma, and this is the victims of non-consensual distribution of intimate imagery and victims of CSAM. So the types of things that these victims will include in their victim impact statements, for example, are very similar. So there's a fear of recognition, there's an unwillingness to participate publicly in different ways because they don't want to be identified or linked to their sexually abusive material. So we do have a lot of stigma that is going on online, and part of it is that we are allowing all of this material to be up in public view and not doing a lot to get rid of it. So we have sort of the big companies doing the things that they do, but even they can't keep in front of it. And then we have all of the smaller websites that we were referring to earlier in this discussion. There is a lot of issues going on. Thank you.
Thank you very much. Round. It's a 5-minute round for the Conservatives. Kevin Waugh. Kevin, 5 minutes, please.
Thank you, Madam Chair, and welcome to everybody here this afternoon. Mr. Sesmak, you too, you're recently a lawyer. Thank you for that. As you know, C-63 did not expand to include the criminal code. It's not been updated to include deep fakes, and so that seems to be a concern not only around this table, but everywhere. I don't know why, when you introduce a bill, you would not, we've seen since 2017, deep fakes are accelerating around the world, and yet it's not in this bill. So what good is the bill when you don't talk about deep fakes? Your thoughts?
I would echo your concerns. I presume there's an issue with, again, with the international element that the internet and deepfakes present. You could have a perpetrator that's in Russia or some small town in a country we don't have very much familiarity with, and it would be hard to potentially go after those perpetrators. I did note in my paper that there is inherently a limitation in pursuing criminal prohibition of deepfakes. Again, the standard of beyond reasonable doubt perhaps would play into limiting who is convicted of these crimes and the scope and the resources that would be required to actually provide and enforce criminal prohibitions of this kind of behavior. I think that private law, civil remedies, things that are based on the balance of probabilities, potentially there is a wider scope for not criminal justice, but justice of some kind, and at least some kind of disincentivization for engaging in this kind of behavior. So that would be my answer.
Well, I guess the problem with having an extrajudicial bureaucratic arm, which I think C-63 is, it can actually perpetuate harm. And we can see that because victims, and some have mentioned it here today, have to come bravely forward, share their stories with a commissioner that they really don't know, or the body they don't know. That has led actually to no real power. So the victim, I think in this case, is led to hope, and then hope is deferred because there's really no real teeth in the legislation. Your thoughts on that? Because I do think 63 is a bureaucratic nightmare ready to explode if it does get through the House.
I would agree that potentially more could be done than Bill 63 presents. I do note at least that there is the inclusion of a definition or inclusion of the word deepfake in the legislation. And if anything, I think it's a good step forward in trying to tackle and get up to date with the definitions that are being used. I note legislation that was recently passed in Pennsylvania. It's a criminal legislation, and it prohibits the dissemination of artificially generated sexual depictions of individuals. The definition, I won't read it out in full. It's quite broad. Bill C-63, it does refer to deepfakes at least. There's no definition provided. But I think with that respect, broadening up the terminology, as I said, the privacy law torts, they are restricted by their definitions and their terminology to not include this new problem that we're trying to deal with. So to the extent that it gets the definitions more up to date, I think it is a step in the right direction.
Ms. Morrow or Ms. Rourke, the biggest entertainer in the world, of course, is Taylor Swift. So she got deepfaked twice this year, once sexually explicit, and the other one, the debacle that happened at the Grammys, where it wasn't her voice and wasn't her. So how do you address this? There's no bigger entertainer in the world than Taylor Swift. And yet this kind of blew over with little or no news from it, actually. It kind of died fairly quickly.
So there's 15 seconds for the answer.
Go ahead, Ms. Rourke.
I mean, I think actually the deepfakes of Taylor Swift is what prompted a lot of these conversations in recent months. I think it's actually brought this conversation more to the light. I would also add, though, that Taylor Swift has much more resources than the average individual to combat this and to respond to issues. But it does show the difficulty of banning the technology and preventing its reusage and reharming future individuals.
I now go to the Liberals, Talib New Mohammed, for 5 minutes, please.
Thank you so much to the witnesses for being here. I'm going to split my time with my colleague, Ms. Latanzio. But one of the things that we have sought to do in addressing some of the concerns related to online harms, and in particular some of the issues that have been raised during the course of the study, is making sure that our legislation C-63, the online harms bill, takes some of these challenges head on and works. An idea, as we've said, we're willing to work with all parties to ensure that it's the best possible bill out there. During our meeting, I don't know if you had a chance to follow the deliberations of our meeting on Tuesday, but our colleague Ms. Thomas raised what I would argue was a very important concern in a number of her questions. The notion that it would appear, at least from my read of it, that she was advocating. I don't want to put words in her mouth, but this is the way that I understood what she was suggesting, is that we take a risk-based approach in legislating in the legislating of regulations around social media platforms. Our belief is that this is exactly what Bill C-63 proposes to. I guess my question then would be: how do you see? Do you agree, first of all, with Bill C-63, what we're trying to do, and Ms. Thomas and indeed others, that the right approach to legislating regulations around social media platforms is really to take a risk-based approach? And I would refer that question to you, Professor.
Thank you very much. As you know, I want to be blunt. I don't have a horse in this race, and I want to also say, in my attempt to make my words brief, I was also a member of the advisory panel, and I also want to say we didn't agree about everything, and we were very congenial, and I think very thankful to everyone's contribution, but we had mixed views on things. But I guess I do lean towards that idea of the sort of risk management about it. And I guess where I'd also like to put a little bit of faith in is I'm more optimistic about that, because in this idea of concepts that we're wondering whether, I think we've heard the term teeth being used. What's handy about not having specifics is that those concepts can be what they need to be at the time that some topic is brought up. And there's another idea in law about that happens sometimes when things are too specific and we don't have a sort of moving forward approach that might have some moments where we try and improve things, is there's a concept called freezing rights. And perhaps the most notable place we might have thought of that has been in the interpretation of fiduciary obligations, mainly to Indigenous peoples. And what ends up happening is case law has to come back to the courtroom to then redefine something. And then that case is compared to previous cases that have a very specific definition. Then the legislation has to come back and has to be redefined. And if there's regulations, then the regulations have to be evaluated. So you end up coming to the place we are here. And that's what I'm very afraid of happening. And so the way I see that as, is law is a work in progress. And there's a very cliche, if not cachet, idea that law is like a living tree. And that idea of having faith in people like you to sort of evaluate things, and when it's important to contribute to the regulations, we can dive deeper to decrease potential risks we suddenly see, or also thinking that what actually can be very intimidating to other parties is that there isn't a specific, so that they might be very nervous what is going to be potentially done by them just might qualify even if it's not mentioned. So I'm very supportive of it.
Great, thank you. And with the minute that I have left, I'm going to give the time to my colleague, Mr. Latanzio. No.
It's now 49 seconds.
Okay, Mrs. Shanks, so the question is...
So I'm Shanks, thank you.
Yeah. So thank you, Professor Shanks. So in your presentation, you mentioned making the two observations. So I'm going to go, you just discussed the first one. I'm going to go with regards to the responsibility. So the question there is, how is Bill C-63 addressing the notion of responsibility?
Well, I guess I'd like to see, I'm going to tweak again. It's, I see it as responsibly as compared to responsibility, because in law and legislation, there can be that word as well, too. I see it as a way to prevent some problems that especially come up in civil actions. And I see it as a very comparative idea to, for example, duty of care in negligence. And I also see it as a very similar comparison to something that used to be called nervous shock, but is now the idea of mental distress. And so what I really like about it is that it is, and maybe perhaps this is already connected to what I said before, that it's going to help speed up some really important evaluations that I think could get really slowed down by thinking of things, for example, in a civil way. Thank you.
Thank you very much. We've gone well over time here. Okay, I'm going to go now to Mr. Shampoo, Martin. 2.5 minutes, please.
Merci. 2 minutes et demie, très rapide.
Thank you. Very quickly. I'm going to try to ask my quick question. So, Professor Shanks, you were part of the advisory committee named by the government. So, is there foreign legislation that you based your work on in the committee? That you based your committee or your recommendations are? Is there something being done elsewhere in the world that inspired or that could be used to inspire our fight against this crime?
Thank you for the question. I would say we very regularly were able to talk about the United Kingdom and the EU and Australia. I was not at all a person who could contribute on those specific moments, but I would say particularly with the UK, I found myself thinking that how we were being influenced by what we could have done was based on perhaps the imperfections, if not shifts of things that we could learn from what was happening in the United Kingdom. So, sometimes the benefit of being a little bit slower, if unfortunately a lot more slow, is you can notice what's going on somewhere else and you can do or not do what they've done or not done. And I would think as well, too, what's been handy, especially about those comparisons, is learning about stages that are very similar to what we've done here, to think of that idea of input and how things could change over time with people learning more terms like deep fake.
Mm-hmm.
How do you increase the knowledge of that?
Je vais poser la question suivante à
I'm
Madame
going to.
Rourke.
I have a question for Mr. Rourke or Mrs. Rourke and Moreau. So the vast majority of the civilized world does not have legislation to fight harmful content, the content we're talking about. So do you think that as long as there's not a big majority, we will always be kind of subject to having this material spread? Absolutely. And it's not that everybody has to legiferate on this issue, but it has to be in the places where these companies are based. That's where we need to legislate. All right, thank you. I have a few seconds left. Yes, but I think with the time that it takes for interpretation, I think we should have a bit of latitude there. I just want to conclude by saying that's what I'm hearing from the witnesses is that if we added deep fakes in the definition of images in the criminal code, I think that would be an important step in this bill. So I just wanted to add that.
Ashton, for 2.5 minutes, please, Nikki.
Thank you. My questions are to Ms. Morrow and Ms. Ruark. We know that digital platforms are not being held accountable for the harmful and illegal content they are hosting, something we in the NDP have been repeatedly calling for accountability. In your writing, and you referred to it today, you've highlighted how somebody like Taylor Swift had a fan base that forced Twitter to eventually take down deep fakes of her, when we know that regular women simply don't have that option. In your view, would something like a digital safety commissioner that could force the removal of these types of images be helpful?
I think the role of a public regulatory body is necessary. I think to leave it to individuals to have to police their own content or to have to constantly be on the search or vigilant for their own likeness being used on the web, I think that's just an unrealistic expectation for individuals to have to maintain their own protection in that way. I think it underestimates the level of just accessibility and widespread use of the technology and how difficult it is. I think I know it's also happened to voice actors for video games that have had their likeness used and manipulated. And even for people who have these fan bases, like you said, even if they're not Taylor Swift, but smaller individuals that can have a following and are recognized, it's even difficult for them to locate all the content and constantly have to notify different hosting platforms to have it removed. So this idea of self-policing, I don't think is a practical solution.
Mm-hmm. Okay, we know, and it came up on Tuesday as well, the devastating impact that all of this, particularly the non-consensual distribution of intimate images, has on mental health, including long-lasting impacts. One of the witnesses on Tuesday, Ms. Lalonde, talked about how frontline groups that specialize in helping people cope with the fallout of these situations don't have the support they need. Do you agree with this statement? Do you think the federal government should be funding mental health supports, but with including with a particular focus on working with victims and survivors in this area?
I'm not looking to be extremely prescriptive, but I do think that 100% that would be beneficial for the victims to have that support wherever it comes from. And I do think the House of Commons has leadership to do something around that, maybe coordinating, funding, or finding ways to be able to make it more accessible to the public.
Ms. Ashton, I now go to Mr. Good for the Conservatives for 5 minutes, please, Jacques. Mr. Lawrence, Mr. Good. Mr. Good is up now for 5 minutes, please. Thank you.
Madame la Présidente.
Thank you, Madam Chair. Thank you to all the witnesses that are here today. I have two questions, or my question rather, will be for the representatives of McGill. You spoke earlier about education and prevention, and that would be an important thing to do. Should this be done in schools, or should this be broader? You know, even in social networks, everybody's on social network. So would that be a possible option? Absolutely. I think that everything that you've mentioned are good options. So schools, you know, that's the physical place where a lot of these interactions take place. And, you know, these young people then socialize online. So I think they have a role to play. And I think platforms as well have a role in educating users, you know, whether it comes to distribution of material or even making material. I think we see a lot of platforms that are leaving this content be created, like nudes. We have to make sure that they have to, you know, that there's consent, but these platforms know full well that nobody's doing that kind of work. So I think we have to give them an incentive so that they offer more protections when people use their platforms. You know, if they want to get money through their platforms from the public, they have to work. I have 7 grandchildren, and this scares me when I hear this. There are things that we can't control. Producers are using applications and IA to produce content that can really destroy lives. Can we not create tools with using the same technology to counter this? You know, we can't have people surveilling or supervising monitoring these sites 24 hours, 24/7. But so when somebody notices that their children or their grandchildren are on a website, you know, it can take such a long time. You know, these can be rebroadcast millions of times already. Can't we have a technology that would just delete all that?
programmers ourselves, but I think it's definitely possible to have and I think that's one of the reasons why public regulatory bodies ought to work with platforms, because they would understand how these systems work and how they could be used to help regulate the content. I mean, platforms already do content moderation. Any of the major tech platforms, YouTube, Google, Facebook, etc. So it's a new wave of content that they'll have to account for in their current systems. I think.
Si je pourrais vous donner une baguette magique.
Now, if I could give you a magic wand for something that would really make a difference, what would you advise us to do?
I keep going back to this, but I really do think that there needs to be a relationship built with platforms and an accountability for the platforms. I think what's so shocking to me is really just how accessible this technology is. And I think as long as it remains that accessible, it's inevitable that there will be more people harmed. And one thing that I really felt frustrating when I was looking at it was just the way in which the technology is presented in this very neutral way, in a gender neutral way, and in almost as if it's not deliberately intended to do harm and to create non-consensual pornography. The way these platforms describe themselves, one example, sophisticated AI algorithms to transform images of clothed individuals. They have a disclaimer that it should comply with law and be consensual, when clearly that's not how they're designed to work, and they have no control mechanisms on there to ensure that any of the images being used are being used in a consensual manner. So I think as long as it is that accessible and not challenged, we're going to continue to see these harms, and I would start there.
Thank you very much, Mr. Good. I now go to Rachel Bandayan for the Liberals. 5 minutes.
Oui, merci beaucoup et merci.
Thank you very much. And thank you to my colleagues. This is not my usual committee, but I'm very happy to be with you today. I'd like to start by saying that I agree with the proposal made by Mr. Champoux and the amendment that was suggested, and I hope that the committee will look at it. So, Maître Moreau, now I believe that you said that trials are long and costly, and I agree. I just want to make sure that it's clear that what you're saying is that the time that it takes to get a decision, it's by the time you get a decision, it's too late. Yes, and I just want to clarify, I'm not yet a lawyer. I have 6 months left to go, but yes, absolutely. We can't really realistically think that everybody that has a deep fake, somewhere on the internet, will go through the entire legal process, go to court. There's so much content and so much material that is problematic and that impacts people, that we need to find more practical solutions than that. And to build on Mr. Gould's question, now, I understand that you're not technicians, but it might be preferable if the platforms themselves or the technologies themselves can identify deepfakes even after these images were put online, but quickly, and maybe that technology exists already, or maybe it's on its way. Is that the case? Yes, if there's that possibility, I think platforms should use that. And I think there are platforms that are already playing with AI to moderate content on their platforms. So I think nudity is already an aspect that they're looking at. All right, great.
Professor Dom Shanks, allow me, taking off the lawyer hat and maybe putting on the mother hat, to ask you how the online harms legislation that we put forward will empower users to flag harmful content. I am worried that we are literally asking parents to police the internet, and I would like to hear you on the tools that are in the legislation that might come help in that regard.
I think that's a great question. I'm going to keep a lawyer's hat on, though.
Yes, please.
About answering it. I think one of the things I do like to be put forward in whatever happens, and that's the way I'm going to put it, is whatever happens. I really appreciate the idea of, and I might say this too because of your professional work hat or cap, to have some functions that are very similar to what have been trends in administrative law.
Yeah.
Because the thing I'm the most concerned with is that people feel like they can be themselves, people who have less access to legal counsel, people that are working with whatever commissioner ombuds office is functioning, that they can also have the space that administrative law has often had to think of sort of some spontaneous adjustments to procedure, which means, everything from having translators that don't only speak English and French, for example, to having things like literally a comfortable chair. I think Cindy Blackstock has brought up many topics in what she has done about thinking of the long list of little things that can make people feel more safe. And that's probably my biggest bailiwick, is to think of whenever there is a moment where we can think someone can call an official space, whether it's a toll-free number or filing a written report or something, that they feel like the support system is right there. And I think in criminal law functions, as someone who's worked a lot for the Crown in the past, and then connected with law firms, that first stage of getting things going is incredibly intimidating to people not trained in law. And I want to find as many ways to avoid that as possible, and think that we have every obligation to provide that. And I did mention earlier that idea of
Thank you.
Fiduciary obligations, I think, is one of the best ways to help us imagine those ways, because
we're well over that time.
Okay.
Thank you very much.
Okay.
I'm going to go now to the next round, but I don't think we can finish a full round, guys. So what I'm going to do is to do 2 5 minutes and the block and the NDP 2.5 minutes. It gives us 15 minutes left, which will bring us exactly to 5:30. Thank you. So I start with Philip Lawrence for the Conservatives. 5 minutes, Philip.
Thank you, Chair. I want to go to you first, Ms. Saint Germain. In earlier testimony, I just wanted to, first of all, confirm that I heard what I thought I heard. You said your organization currently has flagged, I don't think you said the quantum, but I would assume a large amount of material that is that you've already classified as non-consensual or otherwise inappropriate. Did I get that correctly? Is she still there? Oh, no, she's not. She's gone. Okay, my apologies. My apologies. I'll go with that line of questioning to you, Ms. Rourke, and you, Ms. Moreau. My challenge with the legislation is, well, directionally I agree with it, is that I don't think it's going to help enough people quick enough. And so when we already have the internet awash with non-consensual pornography, child pornography, and this legislation will, someone's got to complain about it, they've got to go to commissioner, it's got to get removed. So I see opportunities to improve this legislation by including automatic removal of deep fakes or just in non-consensual pornography that's already been flagged and been tagged. Do you think that there's an opportunity there or no?
I wouldn't, I think, be prescriptive on an amendment for this specific bill, but I do think that there should be work done around that. If it's a future bill, if it's a report, or even just working with regulators in order to be able to do something like that, I think that would be really great. Yes. Thank you.
Yeah, and just continuing along that line, so there's a number of different levels that we could put enforcement on. One is the creator of illegal pornography or illegal deepfakes. There's also the platforms, and then there is also the devices, the computers, the laptops, the phones. The bill doesn't, of course, capture a lot of that. So I don't think just because we can't necessarily enforce all the mice, we shouldn't. We should then not enforce the elephants as one example. So I believe that we should consider going after the platforms directly. Would you agree with that?
There's an expression in French where we say "le mieux c'est l'ennemi du bien." I think that currently having work done on this issue is great, and I think that technology is not going away, AI is not going away, and more work is going to be coming down the pipeline, and hopefully you as legislators will be able to do that work quickly enough to catch up. But I think that it also makes us understand that when we're making legislation now, we have to actually be looking 5 to 10 years, even sometimes 25 years out. We can't just be legislating and working on right now issues. We almost have to be working on future issues.
Yeah, I completely agree. What I haven't heard much testimony, I would be curious that any of the witnesses, if they have something to say, is actually on the device level as well, because the manufacturer, almost by definition, has to be an elephant, right? There's actually a limited number of companies that manufacture smartphones, that manufacture computers. Is that something that anyone's come across in their research as a possible way of reducing online harms?
Well, I think the difference between manufacturing a computer or a phone versus AI technology is that even if the initial software is developed by a larger company, it's now being made open source. And once it's open source, that code can be modified, it can be appropriated, and there's really no way to take it back out of the public domain once it exists there. But I think it's a difficult question. Whenever you're talking about innovation in the context of innovating technologies, and there are multiple different applications, and what are the ethics of that, and how you balance that with what is essentially a huge economic incentive to invest in AI technology and its development, and to have the ability to experiment with that technology and see where it grows, but still acknowledging that a technology like this has a lot of harmful applications, and as far as we can see, it's fairly limited commercial application, and like film and media and these kinds of areas, but clearly can be manipulated not just for sexually explicit material, but for many other purposes as well.
I believe that's my time.
Thank you. That's it.
I was going to thank you for
very
all
much.
your great work.
I now go for the Liberals, Ms. Latanzio Patricia, 5 minutes.
Thank you, Madam Chair. So my question will be again to Professor Dom Shanks. Professor, are you familiar with the proposed changes in Bill C-63 with regards to the Mandatory Reporting Act?
I've got it open here right now. So are there some specific sections you'd like me to go to?
I just want to know from you if you can outline to the committee what you understand those changes to be. And if you, I don't want to put you on.
I must confess,
Yes.
just because of the short amount of time getting prepared for this, I don't want to say, may I pass on that? But if I don't have enough time right now, I'd love to pass on that.
Okay. So let me go back with regards to the consultation process and with which you were involved in 2020. Can you tell me a little bit more about the consultations that were held, and what, in your opinion, were the advancements that you would think have been made ever since then?
That's a great question, and I at least I found what was really good about the process, in a sense of everyone had a different type of expertise, and everyone could be on the same page of we all want something to happen. What at least I found was that in keeping to our confidentiality and keeping to our goals meant that at least sort of the impact on me was that there's not just going to be this bill that takes care of this issue. And that in the brainstorming that we did together and in the brainstorming that's been done for whatever bill somebody's interested in here, that's not going to be the end of it. And that one of the most important takeaways we need to do is to plant that seed with everyone, is that there will be other pieces of legislation that can be tweaked to match the purposes of what we're talking about right now. And for example, I was inspired to sort of think that in particular, consumer protection law has been one of the greatest ways to have ideas of harm in one area be then even more refined in another piece of legislation. And so, you know, in the spirit of realizing that something may not be in the perfect form that anybody and everybody has in that group, that idea of slowing down is unthinkable. And so at least I know from my experience in it is it's given me at least way more recharge and sort of hopeful creativity to see other pieces of legislation where this topic that the purpose of this bill is to address can then be subsequently brought up. I'll give you one example, like online harm that happens to children in some very distressful situations that are whether it's separating parents or brothers and sisters who are especially, unfortunately, mean. There's things that can be done in family law in the future. And that idea of it's so cliche, but that this is just the beginning is I think one of the hopes I have is that everyone realizes this is just the beginning and this bill is not the end of it.
Okay. And in your introduction, Professor Dom Shanks, you spoke about the difficulty for victims to get specific harms recognized as such, as they're not covered by the existing jurisprudence. So I'm curious to know, how would the Digital Safety Commission and the Digital Safety Ombudsperson, proposed in C63 help us better support victims and make sure they have their voices heard?
Well, perhaps one of the most familiar ways to think of that is that that's a place where I see it as very similar, and I mentioned it earlier, the idea of duty of care. And having a place where individuals are going to have a way to talk about what their harm is in a way that perhaps has never been heard before. And how duty of care has been thought of in the past in some of its other imaginings is that we have to be prepared to learn about a new type of relationship. And that might be students in the same classroom, or it might be a supervisor at a job, or it might be a former partner or girlfriend or boyfriend, but that we have to be prepared.
We have to finish this, and I still have Mr. Shampoo and Ms. Ashton. Thank you very much.
Merci, Madame la Présidente.
Thank you, Madam Chair. What I understand, what I think we all understand, is that it's not going to be a single organization or a single tool that'll solve all this. I think this is a societal question. Everybody has to do their share. So platforms have to do their part, legislation has to do its part, and we have to do our part. So despite the threat that you're describing today, there is not a lot of education being done at the school level, elementary, high school, CEGEP. There's not a lot of education on this phenomenon of deepfakes, and I'm worried about that. You know, I was born at a time where we had, I wasn't born with a cell phone in my hand, you know, but I have the impression that you've grown up more with that than I have. Now, and I'm sure the answer to my question is going to be yes, but what if we started very early, giving tools to students to protect themselves? You know, there are 7-year-old children who have cell phones that have access to internet, and they can access this content. And then by extension, they're, you know, they're vulnerable. So why, why is this not being rigorously taught in schools right at the start from the elementary school level? Why don't we share this or educate them about the risks of the internet and sharing their content online? Yes, it really is a societal project. I don't know, maybe development has to be done in schools throughout the provinces. I don't know. But I think there are two aspects of your questions that are important. One, it's the way that we educate children on new technologies, because often they adopt that technology very quickly or much quicker than older generations. And then the second thing, and I think that's why we are so focused on this issue of deepfakes and pornography, and it's specifically understanding why it's so harmful and why it's a violation. So not only do we have to educate young people to understand that, you know, what happens on the internet has a lot of impact on people in the physical world. And, you know, yeah, we can talk to our friends, our classmates very respectfully, but when we go home and we make deep fake pornography on, you know, it's the same person that impacts. So I think it's kind of hard to see that it's the same person on the screen. Thank you.
Thank you very much. I'm going to go to Ms. Ashton. 2.5 minutes, please, Nikki.
Thank you. I want to go back to your point, Ms. Moreau, about that you mentioned in French, le projet de société. And certainly, obviously, the whole point of us being here and hearing from you is to put together recommendations towards government. All of our witnesses have spoken specifically to this very troubling reality with respect to the misuse of AI, the use of deep fakes, the victimization of particularly women. And I'm wondering if you have any thoughts to share around how this ought to also reinforce whether it's education, but also more importantly, action around equality and an end to violence against women. It seems to me that we can't be talking about the use of deep fakes and victimizing women online if we're not talking about it offline as well. And I'm wondering if, in the spirit of making recommendations, if you have any suggestions on that front, and perhaps Professor Dom Shanks could share some thoughts on that after briefly. Thank you.
Yeah, I think there's, I mean, the first thing is that you have to ask, why is a nude image of a woman so damaging? Why is there reputational harm of that being shared? And what kind of cultural response do you have to women's sexuality, that it's specifically women that are targeted with this, and that, you know, it's 99% of deepfake pornographic deepfakes are women, right? So there is a huge gender skew to that, and I think you have to look at that fact in context with our treatment of women more broadly, and also look at it specifically in the context of physical, as you said, real world violence against women, which is often taking place in conjunction with online violence against women. And you know, many of the revenge porn cases that we've seen litigated and actually go to court have been in the context of intimate partner violence. Revenge porn is often used to threaten partners. If you leave, I will release this of you. And I think that those things aren't separable. I think you need to have education and combating both and see them as fundamentally linked. Yeah.
I was just going to quickly pipe up to make sure I don't take up all the time.
7 seconds.
Ombuds offices can do lots. Thank you.
Done. Thank you. Coming and presenting to us, and for all of your vast knowledge to the very complex issue and the questions. I also want to thank Monsieur Barrault, for sitting so patiently during these meetings, here to help us if we needed him. Thank you, Monsieur Barrault. I also wanted to make one point as a chair. I think you heard that we're now having 7-year-olds exposed to this kind of information. And I was talking to one of our witnesses last week, and she said, you know, that means we're going to have a whole lot of new young generations that are going to become at a very early age involved in this. And so we have to think about that down the road. It isn't just that they're going to be victims, they may be perpetrators. So I think it's an interesting question to ask. And we have these 2 meetings. Would that we could have had longer because it's a very important and interesting subject. But thank you again very much for coming. And I'm going to suspend so we can go into camera. Thank you.